Yes, Mr. Biggs.
Well, good morning, my lord and my lady. I appear on behalf of the appellant,
Yes.
together with my learned friend, Mr. Michael West. On your bench, there should be a piece of paper with the list of counsel. And so I'm supposed to go through the names.
Well, will you forgive me, Miss Smythe or Miss Smith? Is it Miss Smythe or Miss Smith?
Smythe, my lord.
Forgive me. I think I did know that. No, forgive me. Yes. Just have any other issues I need to raise with that? No, I don't think so. Thank you very much.
I'm very grateful. So you've got
Right now, we have had some late flurry of material, which we've considered all the skeleton arguments. We've considered the. Okay, case hasn't been called on yet. I'm sorry.
I think it.
Well, treated as called on. We've read the skeleton arguments. We've read the decisions of the tribunals. We have dipped into some of the cases, so we think we're pretty up to speed with all the issues.
I'm very grateful.
We asked you to provide a timetable, which you have done. We think that is, it's on one view a generous timetable. We are very confident from our point of view that you should be able to complete the argument in the day and a half now allotted. And we make it clear we cannot go beyond 1 o'clock tomorrow in any circumstances.
I'm very grateful, my lord. I think I've got more than enough time. I don't want to tempt fate, but I'm very grateful. We're confident we'll finish by 1 o'clock at the latest, tomorrow at the latest.
Good.
My lord, I'm sorry to add to the flurry of documents, but there's one small document that I would like to hand up now. It's been circulated to counsel for the interveners and for the Secretary of State. It's just a couple of passages from the Commission's guidance note on the withdrawal agreement. My learned friend Ms. Smythe refers to one of those passages, not the subject of this document, in her skeleton argument, and there are other relevant passages that we think the court should see. So if I could, I'll just hand that up now.
Any objection?
No, my lord.
Thank you, Ms. Smythe. Yes. Right. Are you going to refer to this now or?
During the course of my submissions.
Okay. Yep.
The other thing I should just check is that we did file yesterday a supplemental bundle of authorities that goes with my supplemental skeleton argument. I just wanted to check.
We've got that. We've had it all. 4 authorities. Yep. Ending with the Jamaican case.
I'm afraid, my lord, that's the first I've heard about a supplemental bundle of authorities. We haven't had it.
It was served electronically yesterday. But
I'm afraid it may have gone to the government legal department. My instructing solicitor is sick. It certainly wasn't.
Have you got? You've got a clip, have you, Miss Ward? Do you want to just show the index to Miss Smythe, and then Miss Smythe can say if we need to hold things up.
No need to hold things up, my lord. But could I ask that counsel for the appellant emails it to me or to my junior? Oh, I'm grateful indeed.
A hard copy's on its way, but Mr. West is going to email it.
Thank you.
To Miss Jackson.
I'm sure that can be done. Thank you.
Right.
I'm sorry for the.
Well, we've now all got that.
Thank you very much. I think then those are all the preliminary matters. Can I dive right in? So what I want to do, my lords and my lady, is to make a couple of background points or overarching points before I then turn to the grounds of appeal. So what I propose to do is to deal firstly with the correct interpretation and effect of Article 10, 3 and 5 of the withdrawal agreement, which is plainly a matter of central importance to the appeal. Then I want to deal with Regulation 21 of the EEA Regulations 2016 and how that interacts with Article 10, 3 and 5. Thirdly, I want to deal with some overarching points of interpretation in respect of Article 18. and then I'll turn to the grounds of appeal and deal with those grounds in the order in which they appear in the pleadings and skeleton. And then finally, I will deal with the suggestion that the proceedings are academic.
You're going to deal with that last?
Yes, unless, of course, my lords and my lady wish me to deal with it now. I'm of course in the court's hand.
Unless anybody disagrees, you prepared it, so take the course you want.
I'm very grateful. Very grateful, my lord. So, interpretation and effect of Article 10.3 and 5. The appellant's position is essentially the same as the first intervener. Article 10.3 and 5, and in particular Article 10.3 of the withdrawal agreement, has a specific independent meaning, and we submit that it requires that the UK and other states that are signatories to the withdrawal agreement gives an extensive examination and satisfies other procedural safeguards in respect of an application for the facilitation of residence or entry that would fall within Article 3.2a of the Citizens' Rights Directive. And so to make that point good, I should take the court through a number of sub-points. The starting point, I think, is the correct approach to interpreting 10.3. And we would start with Article 4 of the withdrawal agreement.
You want us to go to?
So that's the authorities bundle, tab 1.
Yep.
Article 4 is on page 8.
There's nothing in the preambles.
Nothing that I,
No.
at this stage, would want you to look at. Of course, if the court thinks there's something of value there, then it will look at it. But for the purposes of my oral argument, it's Article 4 that I'd like you to look at now. And in particular, it's point 3 that I'd emphasise. Provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. And then if we turn to Article 10 itself, I'm concerned with 10.3 and 5. That's on page 12 of the authorities.
Yes.
And the submission is that Article 10.3 and 5, and indeed Article 10.2, are intended to mirror Article 3.2a of the Citizens' Rights Directive, and therefore they touch upon and are concerned with EU law, and so the principles applicable in respect of the interpretation of EU law mentioned in Article 4.3 have to be considered in the way indicated by that article, Article 4.3. We also submit that the approach taken by the European courts to Article 3.2 of the Citizens' Rights Directive is important context against which Article 10.3 and 5 must be interpreted.
Is that a reference to Rahman?
It is. I'm going to come to the Article 3.2 case law right now. So those points, I'm making those points simply to explain why the Article 3.2 case law is directly relevant to the interpretation of 10.3. And so turning to that case law, think it may be helpful just to start with the domestic authorities first, very briefly. The first of which, the most recent of which, sorry, is the Selic case. Selic.
Yes.
I don't think we need to turn it up, although I'm happy to turn it up if my lords and my lady would like to.
Well, do you want to just cite the paragraph numbers you're going to rely on? If you don't
paragraph 13 in particular. Selic is at tab 15 of the authority, page 445 on this.
Tab 15. Yes.
And paragraph 13 on page 450 to 451 helpfully summarises, albeit in a very condensed way, the legal principles in respect of Article 2 of the 2004 directive. And the point that I emphasise, perhaps it is worth just turning to this passage.
Okay, so it's tab 50.
Lord.
Paragraph
13, page 450 in the authorities.
Yep. You want us to read it?
Yes.
Thank you. Yes.
So it's the sentence beginning, the criteria used.
Yes.
10 lines down, which I respectfully submit is of particular significance in this case. There you see this court summarising the minimum procedural requirements imposed by EU law in respect of 3.2 of the directive.
And as my lord said, that refers us back to Rahman.
It did, and I'm going to come to that. Perhaps I'm being a bit too slow with this, but I thought it might help for the court to look at the way that the domestic cases have interpreted 3.2 and Rahman and Banger as well. Yes. The other domestic authority relevant here is the A. Banji B case. I'm sure I'm mispronouncing that. It's tab 27. And in the light of my law's observation, I don't propose.
Okay, well just
I'll
make
give
a
you the
note
reference
that you
point, but
see also.
Yeah.
Okay. Thank you.
So it's paragraphs 24 to 25 and 28 to 30.
24 to 25. 28.
And 28 to 30.
Thank you.
Right. And the point that those passages demonstrate, and the language that Lord Justice Laws uses in his judgment in that case, is that there is a procedural right. There is a right, but it's of a procedural nature. And it's a right to facilitation, as that term is ordinarily understood. So there are minimum procedural protections imposed by Article 3.2 of the directive. And now to the key authorities, the European cases. Rahman, tab 38. Key passages I respectfully submit are paragraphs 22 to 26. Those passages begin on 1067, page 1067. Paragraph 22 actually begins on 1068, but the line marking the entirety of the section in which those passages appears begins on 1067.
So 22 to 28.
22 to 28 is what I emphasise.
Okay. Do you want us
to
read those now, or Are you going to?
To save time, I think my lords and my lady can look at those in
obviously,
due course. But if we just very briefly go through them together, it may assist. So 22, line marking C on 1068.
Yeah.
In order to meet the minimal obligation to facilitate that's mentioned in 21.
Make it possible to obtain a decision.
That's it.
You draw those two words out, or those two phrases out, do you?
Indeed. I do, my lord, and I'm very grateful.
That is founded on an extensive examination of the personal circumstances.
That's it.
And justified by reasons.
That's it. So that's the key or a key procedural right that arises as under Article 3.2. It's directly effective, and it is central to the determination of the issues in this case in my submission, because it informs the construction of 10.3. And then
23 then identifies some of the factors that have to be taken into account.
Indeed.
I'm so sorry, on the point that it's directly effective, could I ask Mr. Biggs also to show the court paragraph 25?
Yes, well, I think we're going to go through to 22 to 28.
To 26, my lord.
26.
Did I say 28? I meant to say 22 to 26.
Okay, well, don't worry, Mr. Ryan. We're not going to forget 25 on the way to 26.
I may not emphasise certain aspects within these paragraphs, but I've referred to
you invited us to look at it all together, so I think that's what we should do.
Indeed.
So 23 and then 24. Anything you want to say in 24? About 24?
Yes, so wide discretion, but
must come with the meaning of facilitate.
So wide
well, this is really what was said in Shellick, isn't it?
Indeed. Wide discretion, but bounded by EU law, controlled, if you like, ultimately by the procedural right conferred by EU law. And then you have paragraph 25.
Okay, well, we'll just read the first part of that to ourselves. If you'll give us a moment, Mr. Biggs. Yes.
So here there's reference to judicial redress procedures as part of the procedural safeguards imposed as minimum requirements by Article 3.2. My learned friend can explain why she considers this passage to be significant in potentially undermining the appellant's case in due course. We submit that it doesn't undermine the appellant's case or the arguments presented by the interveners.
I think it was in relation to direct effectiveness, and that it's left to national legislation to decide how to give effect to it, but subject to the procedural safeguards which are directly effective. I suspect that's what Ms. Smither was hinting at.
Very well. Well, perhaps I wasn't sufficiently clear. We accept that. It's the procedural safeguards, I say, that are directly.
It says what it says.
Yeah.
Mm-hmm. Right.
And then 26, a helpful summary, top of page 1067. And you've got those 4 indents. But for the purposes of my oral argument, I would emphasise the middle one. It is, however, incumbent upon, etc. You've also got, just perhaps to meet what my learned friend may say about paragraph 25, the final indent, which plainly indicates that the judicial review procedures that are mentioned in 25 are separate minimum procedural rights or procedural entitlements. So that's Rahman. The other EU authority that is important in my submission is the Banger case. That's at tab 29. And the key passages, just to flag them for my lady and my lords, paragraphs 38 to 40, beginning on 873, and then in particular 42 to 52 on 874.
Sorry, can you just give me those?
Yes, paragraphs 38 to 40.
Thank you.
873, page 873, 42 to 52, 874 to 5. If we go to 873 very briefly, line markings P to H. This is essentially a summary of the points we've seen in Rahman. And so I don't take the court through them again, but they're there. At 42 to 52, on the following page, 874, we see something potentially new. Here the court is considering the minimum procedural safeguards that are required by 3.2 of the directive in terms of judicial redress procedures. And the conclusion that we get to, that the court gets to, at 875, I'm sorry, I think I said, yes, no, 875 is at 52. And I just emphasise that concluding paragraph. Article 3.2 must be interpreted as meaning that third country nationals envisaged in that resolution must have available to them redress procedures in order to challenge the decision to refuse a residence authorisation, etc. And that those redress procedures must allow for a factual examination.
I'm so sorry, it's my fault. Which paragraph are you reading from, please, Mr. Biggs?
52, my lady.
52.
875.
Is there anywhere in the European jurisprudence anything in relation to where you've made, this is all if you've made an Article 3.2, we all know that the appellant's case is that he made a mistake and made the wrong Article 2 application or citizen rights directive.
She, my lord, but yes, absolutely.
Well, I thought that the Upper Tribunal had allowed in, for reasons that are not clear, a witness statement which made it clear that he was doing it on her behalf.
Oh, I'm so sorry, yes,
Yeah.
that's right. That is right.
The brother had done it. Anyway, so he'd made a mistake. Is there anything in the jurisprudence which deals with where they've made the wrong application and how you read facilitate in those circumstances? Because, I mean, the Secretary of State's answer is pretty simple. Yes, we agree with all this. If you make an Article 3.2 application, but you didn't, you made an Article 2 you shouldn't have done and you failed. Is there anything that helps us beyond
These sort of general points.
Yeah.
I'm afraid not.
No, I couldn't see it, but I just wanted to check.
I'm grateful. And I think the reason why not is, and I'm going to come to this in terms of the way municipal or domestic law deals with the procedural requirements for making a 3.2 application. The reason that the European authorities to date haven't looked at this is because strict procedural requirements are not likely to be a problem in terms of these minimum procedural protections that are directly effective. Because you can always apply again. If you made an error in the past before Brexit, you could just apply the next day when you realised your mistake. But Brexit changes the landscape, we respectfully submit.
I mean, you're going to emphasise the phrase sufficiently solid factual basis, aren't you?
Yes.
It shows that it's really got to be a substantive analysis.
Yes.
In every case.
Exactly.
In order to comply with the facilitation obligation.
Yes, and this authority is potentially particularly significant to my ground too, which concerns the correct interpretation of domestic legislation that gives rise to a right of appeal from a decision, an EEA decision. And there's obviously an issue between the parties as to whether we had that right of appeal in this case, and that turns on whether on the correct interpretation of the domestic legislation there was in fact an EEA decision. But I'll come to that in due course. The point I'm making here is that this is an additional procedural protection which makes clear, which is to the effect that, UK law has to provide a judicial redress procedure that allows for a factual examination. So judicial review on its own wouldn't normally work, for example, and in this context, the issue was, should there be a right of appeal to the tribunals? And the European Court said yes, for these reasons. So that's the Banger case. The next thing I should deal with in respect of this first chapter, the correct construction of 10, 3 and 5, is the procedural entitlements under the withdrawal agreement, which we say, to some degree, reflect the requirements under Article 3.2, but also general requirements of EU law in terms of proportionality and administration.
So we go back to the withdrawal agreement.
So back to the withdrawal agreement. And back to Article 10 itself, which is at page 12 behind tab 1. If my lady and my lords are there, you'll be familiar with 10.5, I'm sure, from your pre-reading and from the authorities. It's very clear, extensive examination absolutely reflects the language of 3.2 of the directive and the minimum procedural entitlements that we've been looking at in the Rahman, at least in the Rahman case.
Can I just ask, in relation to the point you've made, which is the reason it never got up to Europe was because there hadn't been the Brexit situation before. How many other cases feature this sort of problem? Do we know about? I mean, the Independent Monitoring Authority may be able to answer that. Do you know or not?
I don't have that information, I'm afraid.
No.
Well, I don't have the information at my fingertips. There are other cases, and it's of course been before this court in Selic. There's a couple of other cases in the bundle, Batul, Ahmed, where it's been before the Upper Tribunal. My understanding is there are, I think Melanie Fenn referred in her skeleton to another case proceeding in this court that might have been a suitable vehicle if this case had been deemed academic. So it is an issue that is arising.
Well, it would help to know how many it is. Thank you.
I think between the interveners we can probably come up with the information.
Yeah, well, it needn't be answered now. We've got a day and a half. Thank you very much.
Great. One of the many advantages of having interveners here is that point may well be something they can help with.
Thank you.
So that's Article 10.5. Article 21, the withdrawal agreement next, page 18 of the authorities. So you'll see, well, you can read it, my lords and my lady.
Yes. 21.
21, top of page.
Yes. Yep.
Safeguards set out in Article 15 of the 2004 directive apply in respect of residence rights of the person referred to in Article 10, which of course could include does include 10.3. Now, in our skeleton argument, we've set out the provisions of the CRD, the Citizens' Rights Directive, that are incorporated by reference, if you like, by this article. I can take the court through them now if that will assist, but it is a bit of a maze.
Entirely up to you.
Great. Yeah. Well, I'll do it very quickly if I may. So the starting point is that Article 15 of his Citizens' Rights Directive. That's at tab 2, page 60. So, procedures provided by Articles 30 and 31 shall apply by analogy. And so we look at 30 and 31. 30 is on page 72. Page 72 of the authorities. And my lords and my lady can
Yes.
Precisely what that says in due course. 31 on 73, going over leaf. 74.
So is there anything in Article 30 that helps?
Unless I've missed something, no.
Right, so we can bin that one. But it's Article 31 which you rely on.
31.
Okay.
So you've got, and this is explicitly headed, procedural safeguards. 1, access to judicial, administrative redress procedures.
Yes.
On grounds of policy, etc.
We don't have to worry about 2.
No expulsion decision.
3.
And 3 is potentially significant. Second sentence.
Disproportionate.
Exactly. Reference to Article 28.
Mm-hmm.
So we have to go back to Article 28. Which is on page 71. Protections against expulsion. So it may be that these apply by analogy. Now, I understand my learned friend's submission is they don't apply because you don't have residence rights. And there's no expulsion decision.
Yeah. Well, Article 8 is about expulsion.
Yeah.
So
and
you're not saying it applies directly, you're saying it applies by analogy.
Exactly.
Because of the way 31.3 is framed.
And the incorporation by reference of all of this in the withdrawal agreement. My learned friend relies on the Chenchulia case at tab 25. Probably worth just looking at that.
Right.
Tab 25 begins at page 795. I think passages that my learned friend relies upon are 80 to 87. I think they begin at 798. So tab 25, 798.
I'm so sorry, Mr. Biggs. Just give me the paragraph numbers again.
80.
Yes, on 777. Thank you.
Yeah. Begins at 798.
Sorry. Begins at what?
Page
798. Maybe that there's an advocate. Yeah, it's the judgment, not the Advocate General's.
Okay. No, it's just you've got paragraph 80 flagged in the Advocate General.
That's entirely our fault. We've done the sort of schoolboy error of marking up the Advocates General.
Well, I made the schoolboy error of following it.
As did I.
Only with my encouragement.
School person error.
Only with my encouragement, my lord, and I take full responsibility.
Okay, so anywhere on 798.
That's
I will now
sorry.
flag.
I need to catch up.
It's 80 onwards, is it?
80 to 87, so 798 is the following. And I think it's probably 87 in particular that my learned friend would emphasise, although I don't want to put words in her mouth.
Well, that's going to take us back
Right
to
of
65.
residence.
That takes us back to 65, doesn't it? That's just summarising.
Yes, it is. And I think the point that's being made here is that by analogy means something like mutatis mutandis. That's paragraph 81. At the bottom of 798, at the top of 799.
But if it doesn't mean that, what does it mean?
I don't dispute. I think that's right. It must mean that.
Right. Okay.
So I'm not making I'm not placing any particular weight on this. I'm simply trying to take the court through these provisions. I don't place great or any reliance on 28 of the Citizens' Rights Directive, but I do say proportionality applies by virtue of, I think it's 31.
So how are you going to get round the residence point?
Well, I appreciate that's difficult in this case. Obviously, though, if this wasn't an out-of-country case, which of course it is, and the person was in the UK with a pending application made indisputably under 10.3 before the Brexit cut-off, the transition period ended, they would then, we submit, be entitled to reside in the UK until a decision in accordance with 10.5. That would, in my submission, plainly be a residence right. So it may be that these specific points are difficult for me to found my whole case on because of the fact that the appellant is out of country and is asking for extensive examination of an application for facilitation of entry and not residence. But in other cases where 10.3 applies, these rights are all there. And in my submission, this informs the overall approach that should be taken to 10.3. Right. And it's fair to say that 10.4, for example, talks about rights of entry and residence, suggesting a sort of composite. So those are the provisions within the withdrawal agreement and the Citizens' Rights Directive. And there are also, in my submission, the general principles of EU law which should be considered when interpreting 10.3, and they're very well understood. Procedural proportionality, forgive me, and good administration. And I will leave the first intervener to say more about that if they want to. So where does this, well, actually, I should, before I get to my next topic, I should just deal with the Secretary of State's arguments about all of this. Where this gets us in my submission is that there are these minimum procedural rights that arise under 3.2. They are reflected in 10.3 because 10.3 is meant to reflect 3.2. They are also available by virtue of general principles of EU law and Article 21 where it of the withdrawal agreement where it avails someone. And what we submit in this case, and I'll come on to this in a bit more detail, is that the cliff edge effect of Regulation 21 is incompatible with those minimum procedural rights. In the particular circumstances that arise as a consequence of Brexit. And so Article 10.3 should be interpreted so as to allow an application to fall within its ambit, to apply to an application, even where Regulation 21 is not satisfied. Because to do otherwise would be inconsistent with the directly effective procedural rights that arise. Now, my learned friend's response to that broad point is, as I understand it, to argue, this is paragraphs 48 to 51 of my learned friend's skeleton argument, is to argue that the Article 3.2 case law simply shows that the UK is entitled to adopt a domestic procedure for the recognition, for the facilitation of 3.2 applications, and she points out that there are authorities that indicate that under domestic law, the Secretary of State is not normally obliged to consider application A, when in fact the intention is to make application B. And our short response to that argument is that none of the authorities that my learned friend relies upon assist the court because they're simply not concerned with the minimum procedural protections or procedural rights, to use Lord Justice Law's language.
I'm sorry, you dropped your voice then.
I'm sorry, my lord. Our short response to the Secretary of State's reliance on these various cases that talk about the various different contexts, the Secretary of State can say, no, I'm entitled to insist on only considering application A, rather than looking at whether you've made application B. None of those cases are of assistance because they didn't concern the demands of the minimum procedural protections that arise in this case on the correct construction of 10.3.
What do you say about the findings of fact that the First-tier Tribunal made, which was, I mean, whether they're right to make or not, no one's challenged them, that this was an application that could easily be navigated, that was clear and all the rest of it? Paragraphs 18 and 25.
Of the First-tier Tribunals?
Yeah. Because it's the First-tier Tribunal that's made the findings of fact.
Yes.
Although, as already indicated, the Upper Tribunal seem to have allowed in further evidence, and no one's really addressed how we square that.
Yes.
But the procedural, my understanding of the Secretary of State's argument is not just you made the wrong application tough, it's you made the wrong application and we've done everything to make it clear which application you should be making, and that was the procedural safeguard to which you're entitled.
It may be that I'm fixed with the findings that have been made below and I haven't been challenged. Our submission is those don't go far enough, and the Secretary of State's argument as my Lord has summarised it, is wrong because it sets the bar too low.
It's insufficient facilitation.
Exactly.
Case.
Exactly, because the reality of the situation here is that, for whatever reason, the wrong application was made. And we'll look at how Article 18 deals with situations where the wrong application is made in due course. But it was nevertheless, we respectfully submit, on a fair reading of the materials that constituted the application, apparent that the intention was to rely on a relationship that fell within 3.2a. And so that, we say, is sufficient to trigger the 10.3 and 10.5 obligations on the correct construction of those provisions. And that required the Secretary of State to give the extensive examination that's required by 10.5 and EU law principles. And indeed also to ensure the minimum procedural safeguards, which include a proper appeal, effectively, on questions of fact. None of that happened because the Secretary of State said you made the application on the wrong form.
And that's what divides you two?
I think that's right, my lord.
Yeah, so it's quite a very short point, really.
I think it's, when we get down to it, it is. But obviously the court may be assisted, I hope will be assisted by a careful...
No, it's very helpful to have the background, but having done the reading, that's what seems to divide your position from the Secretary of State's. Yeah.
I think that may well be the end of it. Yes, that's right, my lord. But, well, yes. So just to...
Now, do you want to say anything about the cases which Ms. Smythe has cited at paragraph 48?
I do, my lord. Thank you very much. That's what I'm just about to deal with. So I'll just very briefly summarise why they don't apply and give you the references to save time.
Okay.
But why they're distinguishable. So I can do that pretty quickly.
So we've got Lord Justice Sales.
So we've got Amatemor, case I'm not familiar with, because I lost it.
Always remembers the cases you lose.
Paragraphs 22 to 25, page, so this is tab 33, page 9645. And
paragraph
22 to 25.
Thank you.
So I'll let my lady, my lords, just have a quick look at those passages.
I'm just scratching up. Forgive me, I'm so sorry, I said it twice. Which paragraph numbers?
964, I hope.
Thank you.
Going over leave.
This is Lord Justice Beatson, is it? No, it's Lord Justice Sales.
the very short point, my lords and my lady, and it's the same point I'll make in respect of the other authorities that my learned friend relies upon, is that this just doesn't assist. It's a very different context.
Well, it's clearly a support for the proposition that Miss Smythe makes in the first sentence of paragraph 48. Under UK domestic law, there's no obligation to treat an immigration application for right B as an application for right A as an application for right B.
Sure, as a general proposition, okay. But an immigration application is extraordinarily general. The way that my learned friend puts it is extraordinarily general, and as a general proposition, that's right. The difficulty for my learned friend is that we're not dealing here with the general run of cases. We're dealing here with whether specifically enforceable, directly effective, minimum procedural safeguards have been met. That's not the context of Amatemor. And so it doesn't...
Are we going to sign the same thing, make the same point, if we look at Rupia and also Lord Justice Bennett's case?
Exactly. So let me just, so I can just, so Amatemor was a case where we were arguing you should look at human rights even though you've made an EA application. And you've got what Lord Justice Sales said about not having to consider the human rights application in that context. Rupia was a case where there was an invalid application. And the point was where you didn't have to, I think, consider the invalid application. That's a very, very different context. There's authority that looks at validity requirements and whether and how those work. So that really doesn't assist at all. But just for my lords and my lady's note, Rupia is tab 30. Relevant passage my own friend relies on is 15.
Yes.
That's at page 882. But you've got my submission, page 882.
Yep.
Bahari and Ullah was a case where it was argued, amongst other things, that the Secretary of State should look at whether to grant leave as a matter of discretion. And the point that was made is, well, you've got to raise the basis of your request for discretion. If you do, then the Secretary of State is actually obliged to look at it.
But does that help you then?
Well, I think it might help us in the sense that, and let's just quickly turn to it. I think
because that sort of, I mean, that feels like where you're.
Yes.
The sort of point you're making here.
Well, I don't think it helps because the context is so different, but it does indicate that if an application raises a request for something, even if the application is made on the basis of immigration rules, if it says in the course of if the applicant says in the course of making the application, in the application materials, consider granting discretion, even though that's got nothing to do with the rules, the Secretary of State is then obliged to consider that. And let me just make that proposition good by reference to Bahari. So, cases at tab 34. And my learned friend relies on 27, I think, in particular, page 979.
Yes. It cannot be expected to chase shadows.
Exactly. Fine. But the point that's being made then, we'll come to the rest of the judgment, which I think makes good my analysis of this case. The point that's being made there is, if you don't say anything about something, the Secretary of State's not required to go on a fishing expedition or whatever metaphor one might like. Chasing shadows is the point. But if we get to the end of the judgment, paragraph 39, page 981, the court does, so this is paragraph 39, page 981, the court does recognise that if there's a request for the exercise of discretion, and the implicit context is even if that request is made in respect of an application for leave under the rules, then it must be considered, albeit that you might only have to give brief reasons addressing it. So that's the legal obligation. So there is, even in the wider immigration context, an obligation to consider things, even if they're raised, in a sense, using an inappropriate form. But this has very little to do with our argument, apart from that point, which I'm entitled to make, because we're concerned here with the demands of specific procedural obligations. So that's Bahari. The other case my learned friend relies upon, and she did rely on this case as well in Selic, is the Macastana case, which is at tab 28. Probably worth turning to this one, because I think my learned friend may say quite a bit about it, I don't know. So that's tab 28. The relevant passages are 15 to 17, paragraph 15 to 17. page 831. And my lady, my lords, will need to look at all of these passages because they are relied upon quite heavily by my learned friend. So it's 15 to 17. But I would just draw particular attention to paragraph 16.
Well, why don't we read the whole of this marked passage?
Yes.
Before we look at 16 in particular. Do you want to sit down, Mr. Biggs, while we do that?
Of course, thank you.
Well, Miss Spy's going to rely on 17, isn't she?
I think that's right.
And you're going to say it's distinguishable because it's looking at apples and pears.
That's certainly what I say. Just to flesh that out a little bit more, if we look at paragraph 16, I mean, the point that was being made there is the Secretary of State should have known about the facts, even though there was no application of any kind that drew those, put those facts forward as a basis for facilitation. That's a completely different context. Maybe the point that my Lord was summarising for me, and I gratefully adopted. The other case that my learned friend relies upon, the final one, I think, is the CS Brazil case. And we submit, actually, this helps us. And my learned friend acknowledges that it might do, and she seeks to distinguish it or to critique it or criticise it in her skeleton argument. So CS Brazil is at tab 40. Page 1081. And I think the relevant passages, paragraphs 9 to 10, paragraphs 9 to 10, page 1086, and 13 and 14, 1086. So if we start with 9 to 10, 1086. Sorry, 1087, second set of paragraphs. So 1086. It's the part of paragraph 9 that starts 7 lines down, the case that Mr. Anderson makes.
Might have applied.
Yes.
The next. Yeah.
And then at 10, there's a recognition that that's correct as far as it goes. Might have approached the Secretary of State, asked for a residence card, etc., or asked generally, etc. So, if anything, that supports the appellant's analysis. And the next set of paragraphs are paragraphs 13 to 14.
So, just so I understand that point in 10, Lord Justice Laws is hypothesising a situation which hadn't arisen in that case. But if it had done, would have added a strength to Mr. Anderson's submission.
Yes. So,
but you say it, but it didn't. But you say, hang on, here it does apply to
here
me,
it did.
or it's close to
Here
my
it did.
situation.
Yeah. In fact, what happened here was a fortiori, because there was an application process that was gone through that raised the basis of a 3.2a application. It's just it was the wrong form. What Lord Justice Laws is envisaging here is something much more generous, potentially. You just ring up the Secretary of State and say, I want to make the application. I mean, I think that would cause difficulties. I'm putting it too highly, but it's our case is a fortiori. Paragraphs 13 to 14, then, just to finish this off, 1087, the next page. And I think I only need to refer you to 14, but you've got the line marking there. I think 13 is the context. 14, the right in question under 3.2 of the directive only falls in, as it were, if the appellant were to ask for it to be done. That's for facilitation, I think. He did not. Now, it doesn't perhaps add very much to 10, but it does show, in my respectful submission, that Lord Justice Laws effectively accepted that there was no requirement for formality for the 3.2 obligation to be triggered. And my learned friend, and that obviously very strongly supports our analysis, my learned friend seeks to persuade the court that these observations are obiter and are wrong. Well, they did form part of the judge's reasons. It's right that the judge, Lord Justice Laws, made it clear that these things hadn't happened, but I leave it to my lords and my lady as to whether that can be brushed aside as mere obiter. But in any case, in my respectful submission...
Well, they're not part of the ratio, are they? They are propositions he's putting forward, which, of fact, which had they existed, the case might have gone the other way, but they didn't. So it didn't.
Yes. But it is an integral... I mean, it's close to ratio, because it forms part of the framework of reasoning upon which the court rests its decision. But in any case, we respectfully submit that Lord Justice Laws was right, and his analysis is not undermined by the points that my learned friend makes. I think one of the points my learned friend makes is that Lord Justice Laws proceeded on the basis that the 3.2 was somehow directly effective. I don't think that's right. But even if the learned judge made that error, it doesn't really affect the point. Not least because, as I've tried to show so far in my submissions, 3.2 does have directly effective aspects, and those are, if you like, procedural rights. And that may be what Lord Justice Laws had in mind. So, the cases my learned friend relies upon just don't assist her argument. Can I turn then to the second chapter of my submissions, domestic law and how it regulates the making of a 10.3 application, and Regulation 21 in particular. The Regulation 21, this is Regulation 21 of the Immigration European Economic Area Regulations 2016. Those are behind tab 6 of the authorities, page 113. And 21.
So was, sorry, which divider are we going to?
Tab 6.
Tab 6.
Divider 6. If you're using the electronic, I think it's 113.
And were these regulations amended after
these regulations
the withdrawal agreement?
I think they were, but the regulations we have are the ones in effect at the end of the transition period. You can see at the top of the page of any pages of this document, point in time view as of 31st of December 2020.
So this is post-Brexit.
This is in transition period.
So just talk, if you wouldn't mind, just talk us through. What's the source of these particular source of these regulations? Were they triggered by Brexit, or were they
No, these are the regulations that have been extant for a very long time that gave effect to the citizens' rights.
Right. I mean, they're dated 2016.
Yes.
So that is, so they were their previous regulations.
There were regulations from 2006.
Okay,
they
fine.
Were
So
then
this
replaced
is
by 2006.
so the fact that it's post the Brexit vote is irrelevant.
It is exactly, well, it's irrelevant in one sense, but we say it's highly relevant in the sense that these were provisions that were designed and implemented in the pre-Brexit halcyon days, and things are now very different.
And do these still apply? Because there's a bit on page 113.
I'm sorry, my Lord.
Do these regulations still apply?
They apply insofar as they have been saved by transitional provisions, and the transitional provisions are very complicated. They don't.
Yeah, well, that's where I'd got to, and, that's why I was asking for your help.
Yeah, I mean, it depends. We have the transitional provisions in the bundle, and we can look at them if we need to. The short answer is generally they don't apply after the end of the transition period, but they've been saved for certain specific purposes, such as where there was an application made under the 2016 regulations that's outstanding after the transition.
That's what the thing in the box says under F1, isn't it?
I think that, yeah.
Regulations revoked with savings in relation to a relevant person.
Yeah.
Blah, blah, blah,
this is
from the grace period.
This is from the government website, and I think that box is entirely accurate.
I'm so sorry. There are in fact two sets of transitional provisions. Those aren't. That note is right, but only in relation to certain persons. The relevant transitional provisions in this case are at tab 9 of the bundle.
So what's the answer to my Lord's question? Is it
So the answer is they are continued in effect with certain modifications. They were revoked generally. They're continued in effect by transitional provisions, one of which is colloquially known as the grace period statutory instrument. The other one is the provisions relevant in this case, which is referred as the consequentials provisions at tab 9. And if the court looks at those, the court will see that they say various things about, so for example, Regulation 12, this is in Regulation 3 of those regulations, Regulation 12 continues to apply for the purposes of considering blah, 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 and then makes various other provisions after that.
So the regulations at 9 are not the regulations in the box at page 113. It's different regulations.
Yes.
So
I hope this is this. It's summarised. I appreciate it in a very summary form. Paragraphs 24 to 25 of our skeleton.
You were ahead of us. Thank you very much. All right. So going back to there's still the yes, they're still in force so far as relevant.
Well, I think I think there's nothing between my learned friend and I. It's just my learned friend was a bit more precise. But the answer is it depends. There are transitional provisions. I think my learned friend is right about the applicable transitional provisions in this case.
So they're in. The answer to the Lord's question is yes, they are still in force for the purposes of this case.
For some of the purposes of this.
Exactly. We may have to look at that when I get to the end of my submissions about whether the appeal's academic. But
oh yes. Okay. Fine.
So,
but in answer to my question, which is from ignorance, which I apologise, this is just the successor to a series of previous regulations, which brought the directive into force, or facilitated the introduction of the directive. Okay.
The first of those that I'm aware of is the 2006 regulation.
Okay.
I'm not quite sure how the directive was implemented before then, but perhaps my learned friend with Smythe or one of the interveners can help if my Lord's interested with that.
Right, sorry, we sidetracked you. Where do we go within the regulation?
So I'm simply concerned at this stage with Regulation 21, which is the validity, sets out the validity requirements for an extended family member application and any other application under the 2016 regulations.
Do we need, while we're in the regulations, is there any other regulations you think any other party is going to ask us to look at? If so, would it be helpful to do that while we're here?
I think the answer to that is no. I think.
Well, that wasn't the indication from the
I
slide.
will be asking the court to look at regs 2, 7, 8 and 12 and 36 and 37, but I can do that in my submission.
Okay, well let's not interrupt your flow.
I'm grateful. To be clear, I am going to come on to the regulations that deal with right of appeal because that's relevant to ground 2, but intend to do that?
We'll take your own course.
I'm great.
21.
The 21, page 130, 130, 130. This sets out the validity requirements for an application, and in particular an application for facilitation as an extended family member for the purposes of Regulation 12 and 8. And I think we will need to look at 12 and 8 actually. We'll go to that in a moment.
Could I ask what may be a silly question, forgive me if it is. But 21.1 says the word relevant appears. So you have to apply by the relevant pages on the website and all the relevant forms. And if you don't comply with the requirements of that regulation, the application is invalid. Does that mean this application is invalid?
I think it does. In the Ahmed case, it was pointed out that, so just to be clear about what I'm referring to, that's the unreported decision in the case of ECO and Ahmed, which is at tab 21. For those using electronic, begins at page 669. I don't propose to take the court to it now, but in the Ahmed case, the Upper Tribunal held that actually there wasn't a difficulty in respect of 21.1a because of the language of 21.1a. So if you made an EUSS application, if I can use that expression, by mistake, because you use the same web pages, if you like, or URL is the reasoning in ECO and Ahmed, then you satisfy 21.1a.
Relevant. That would count as relevant page.
It would count according to that decision, and I think we don't challenge that aspect of the decision. The difficulty we have, and this was a point I think Mr. de la Mare belaboured in, with great respect to him, in the Chelik case, is that's not the be-all and end-all of the validity requirements, because there is also the requirement in 21.2b that the application be complete. And so that requires you, I think, to look at the precise content of the applicable application form, which has to be completed where it's specified that it must be. And I think if that is right, the application in this case must be invalid.
Okay. Thank you.
But our submission, so this imposes very strict, if you like, technical validity requirements. And in the pre-Brexit world, that would have been no difficulty, because your application is made, you don't tick the box that asks for something, so the application is not complete. So it's an invalid application, but you can always apply again, no problem. No difficulty in terms of 3.2 and the directly effective procedural rights that arise there. But as a consequence of Brexit, everything's different because of the cliff edge effect of the transitional provision of the withdrawal agreement and the transitional arrangements. So if, as in this case, you get it wrong...
cliff edge effect when you put it with a late application.
I appreciate there is that point, but one has to consider the overall circumstances and the proportionality of the cliff edge. Obviously, one can steer away from a cliff edge if one has sufficient notice, but mistakes can arise. And the question is the cliff edge effect compatible with the EU law obligations and the correct interpretation of 10.3 that I've taken the court through?
So your point is the protection provided by the facilitation obligations under the withdrawal agreement apply to everybody, even those who are steering close to the cliff edge.
Exactly. And that, and just on my Lord Justice Dingemans' point, it is fair to say that navigating the distinctions between EUSS, EUFP and EEA regulations is not necessarily easy. I know the Home Office puts the case forward that they have acted reasonably and proportionately in providing information, but mistakes were likely to be made. and were made in this case. And the question is a regime that makes no provision for excusing those mistakes compatible with the Article 3.2 and other procedural requirements that I've taken the court through? We say no. And the way to, and what that means is that effectively Article 21 drops out of the picture, and you simply look at whether, as a matter of fact, a 3.2 application has been made. And we say it has been made in this case, and I'll come to that. So, can I turn then to the third chapter of my submissions, Article 18, very different topic in a sense. So this is Article 18 of the Withdrawal Agreement. So Withdrawal Agreement's the first document in the authorities, so tab 1, page 3, and Article 18 is page 14. And what I want to deal with in this section of my submissions is essentially the respondent's notice point. And the respondent's notice point is Article 18 doesn't apply at all to applications by extended family members for a residence permit for entry clearance. So out of country, so not resident in the UK, and extended family members. And we firmly submit that that cannot be right. And the first point which shows that that cannot be right is the text of Article 18 itself. And in particular, Article 18L, 18.1L, forgive me, and 18.1M. And those aspects of 18 show that it must apply to other people, so extended family members, falling within 3.2 of the directive, and 10.3 and 5.
So L1.
Yes, you have it. And also M. And also, if you just look at, and I mean, it's the whole of L, but if you look at L4, for example, just on 16, very clearly applies to 10.2, 10.3, and 3.2 of the directive. Couldn't be clearer. 18.1M also clearly applies to 10.4, people in 10.4. Those are people in a durable relationship, durable partners, which is, if you like, a species of extended family member or other family member under 3.2. And those are people who can be outside the UK, if you look at the language of 10.4. And if we then go back...
10.4.
I don't think we need to look at 10.4. Well, we can if you want to, but it does. There's no dispute that it does say entry and residence, and it concerns durable partners. So just going back to the top of 18, back to page 14, beginning of 18, 18.1. I'd ask my lady, my lords, just to read the whole of that paragraph, and then I'll make the point.
Sorry, which paragraph?
18.1.
Thank you.
First paragraph. So it's the words and other people, other persons, sorry, and other persons. Plainly, that has to be extended family members. And obviously, that's consistent with 18.1L and 18.1M, which I've asked you to look So it plainly does apply across the board, we say, to extended family members. Does it apply to those resident outside the UK? Answer, again, plainly yes. Bearing in mind 3 points. Firstly, 18(1)M, which we've looked at already, that refers, and this is the point made in my supplementary skeleton argument, that provision is clearly concerned with people who are outside the UK. And then if you look at its language, in respect of M2, Roman 2, on page 16, you can ask for a document, registration certificate, any other proof of residence in the host state of the United Kingdom or of the United Kingdom national. So those are the people who need to be in the UK, whom they are joining, not who they have joined. And the next point that supports our position here is the document I handed up right at the beginning of the hearing, the Commission explanatory notes, which sets out what the Commission, the EU Commission, understood at Article 18 to do.
Sorry, the explanatory notes that you handed up.
Yes, it's just a 3 or so.
On our desk when we arrived.
Yeah, I'm grateful to my Lord. So we put line marking on this. Let's start with 2, 6, 3, 4 on page 3. And I'll just let my lady and my lords read that.
So, and just so for my note, these are the explanatory notes in relation to the withdrawal agreement.
Yes, from the EU Commission. And my learned friend refers to.
No, I've seen that.
You've seen them in the skeleton argument. It's just other aspects of that. We think it may be helpful for the court to see the whole of those explanatory notes, and if the court wants them, we can provide them.
And what status do the, if any, do the explanatory notes have?
An aid to interpretation. That's my submission.
Are they referred to in the preambles, and were they agreed by the UK?
No and no, my lord.
I think that's right.
But you've referred to them?
Yes, they're simply commission guidance.
Right. Okay, thank you.
In the broad, applying the Vienna Convention approach, at least, this is part of, if you like, the context and can be taken into account. We do submit that it's relevant to interpreting Article 18, and Article 18 is a strangely expressed provision, as is the case with other aspects of the withdrawal agreement. So, with great respect, any help one can get in trying to make sense of it all is of value, and we respectfully submit that this does provide.
Did the UK government publish any guidance notes?
Don't believe so. I'm looking at my learned friend.
So there's a lot of guidance out there.
No, well, there may be a lot of guidance out there. Did the UK government publish any to this?
Not directly answering the Commission's points, but it has published its own guidance. I understand that originally there was an intention to produce joint guidance, but unfortunately that wasn't possible.
Well, the only reason I'm asking these questions is because if one's looking at the Vienna Convention and trying to be fair about that, travaux préparatoires, everyone accepts. The treaty itself, everyone accepts. But one party only to the treaty's subjective intentions afterwards, one wouldn't normally take into account. It may be very interesting, but one wouldn't normally take into account, unless you can persuade us that we should.
Can I think about that and perhaps come back to it in reply? We respectfully do say that this is a valuable aid to interpretation, at least in the...
Well, I understand your point about 18(1)(m)(2), which you say is forward-looking. So you may not need this, but if you do need this, then you're going to have to get over the threshold of saying that we can look at it.
Yes, I appreciate that, my lord.
And there may be something somewhere buried in some document from the government which gives the green light.
Maybe. Can I think about that further? I mean, as has been pointed out, my learned friend does rely on other aspects of this document.
Well, the fact that she may be wrong doesn't make you right.
Tit for tat's never a good point. But nevertheless, we think it does help. and I'll think about precisely how it can be brought in terms of the interpretive principles, if I may.
Thank you.
Come back to that. But assuming it can be looked at, 2634 is absolutely clear and plainly supports our position that 18 applies to out-of-country applications, including applications by those falling within 10.3 and 4. That's what's said in terms. Completely inconsistent with the Secretary of State's position.
You rely on the second sentence of that guidance?
Yes. Out-of-country applications can also be made, and with reference to 10.3 and 4.
Have we got the guidance referred to in brackets there?
I'm afraid not. This is one of the reasons why I thought it would probably help the court to have the whole of this document, and we're very happy to provide it.
I mean, that.
Well, only if it's relevant.
I have looked at it. I couldn't see why it was particularly helpful, but I appreciate why the court would want to form its own view about that.
Yeah.
I tried to save paper by producing this today in this form, but
But
I think the court should probably see the whole document.
All this is subject to my Lord's point.
I agree.
But, subject to my Lord's point, as drafted, it looks as though the sentence on which you rely on 2634 is simply a reiteration of something that appears in relation to the guidance to Articles 10.
I don't think that.
To 10.1.
Well, I don't have it here to double check, but that wasn't the impression I had.
Was not the impression you had.
No, but I may be wrong about that, my Lord. We will provide it, at least by tomorrow, and if necessary, we can look at it. My learned friend will be in a position to make submissions in respect of this. My learned friend is, I'm sure, familiar with this document. But I'm afraid that's the best thing. I mean, in hindsight, we should have produced the whole thing, so we could look at it now, but we haven't.
Well, it might be. Okay, fine. Well, no doubt you and Miss Smythe will have a chat about this over lunch, or your juniors will, to try and iron out this wrinkle. Yes.
Grateful. Anyway, with the caveat that you may want to look at the text in parentheses at the end of that second sentence, it couldn't be clearer. Similarly, if we go to the first page and then overleave 2.2.2, I think the first 2.2.2 is perhaps not particularly helpful, although it does say something about Article 14, which the joint interveners are particularly interested in. But it's 2.2.3 at the top of page 10. Second paragraph in particular, again, very clearly shows, we say, that the Commission understood 18 to apply to out-of-country applications, because what's being said there is that there's a choice, as the Commission understands it. You can have a 14.3 short-term visa, or you can have a residence document under 18. And it's our submission that actually the Secretary of State in this case has adopted the same procedure for 14.3 as she has for 10.4 applications. And that's the Article 8, that procedure is regulated by Article 18. So, just not to lose sight of the points or the proposition that I'm making by reference to this material, we say this material clearly shows, or indicates at least, subject to it being admissible for the purposes of construing 18, that 18 plainly applies to those resident outside the UK. So that's the end, in my respectful submission, of my learned friend respondent's notice. And as we pointed out, even if we can't rely on this document, you've got the text of 18 that supports that. And I've made the point in the supplementary skeleton argument that there really isn't any good reason why Article 18 should be so limited in scope, so as not to permit the constitutive procedure that Article 18 allows for to be applied in respect of those resident outside the UK. Why would it have that limitation? I ask rhetorically. we would also, and it's a small point, but we would also highlight that the Batul case, so this is tab 20, 613, tab 20. There's no particular passage I'll refer my lady to, so we don't have to look at it now unless the court would be assisted. The Batul case involved a similar situation to the instant appeal, in that there was an application for facilitation. Well, there was an application on the wrong form, but the intention was to make an application for facilitation of entry, so it was an out-of-country application. And there's no suggestion in the Upper Tribunal.
Why not taken there?
Exactly. My learned friend, Ms. Smythe, was in that case.
Yes.
I don't know why the Upper Tribunal didn't mention the point, but I'm entitled to make the submission that if this expert tribunal thought that it was a good point, it would have said so. So just looking at, finally, before I move on, at the language of 18, if we go back to 18.1, on 14. Now this is to some degree speculative, but it's possible that what's happened here is simply a misplacing of a comma or some other drafting error. And the intention was that the reference to residing in its territory in accordance with these conditions is to the United Kingdom or European Union citizens nationals, which on any view have to be in the UK. But I appreciate that that is to some degree speculative. But in my submission, bearing in mind the points I've made, something has gone wrong in the drafting insofar as the language of 1 indicates that applicants have to reside in the territory. So that's the third chapter of my submissions, and now I can get on to my grounds of appeal, unless there are any questions from the bench.
Okay, thank you.
So ground 1, this makes the point that Article 18.10 required the Secretary of State to allow the appellant to correct a mistake, or the mistake that was made on her behalf. And I'll come to Article 18.10 very shortly, but the first point I make, because of everything I've said about 10.3 and 10.5, there was an application that fell within 10.3, even though it was defective in accordance with domestic law, because the correct interpretation of 10.3 requires required the application to be treated as an application for facilitation. You've got the point. So we are within personal scope, insofar as Article 18 can only...
Sorry, you slightly garbled your last bit of this,
yes,
just so that I got your submission accurately.
Yeah.
Fell within 10.3 of the withdrawal agreement, even though it was defective under domestic law because...
Regulation 21.
No. I know why it was defective under... But you were going to say it fell within 10.3 because...
Because 10.3 has to be construed in accordance with the case law in respect of 3.2 and the procedural safeguards I've gone through, and that means that an application for facilitation that is in fact an application for facilitation counts for the purposes of 10.3, irrespective of domestic validity requirements for such an application, because anything else would mean that the application wouldn't be given the wouldn't be considered in accordance with the procedural safeguards that I have highlighted. I hope that's clearer.
Thank you. Sorry to interrupt.
No, not at all, my lord. I did garble it, and I'm very grateful. So, for that reason, we are within personal scope, if we need to be. And I think at this point it's worth looking at the application that was actually made in this case. So That's in the hearing bundle at pages 367 to 375. 367. Went behind tab C. I'm sorry. So this is the application form that was used. And in accordance with the ECO and RMEG case that I mentioned, this form was produced on the same web pages as you would use to make an application under the 2016 regulations. Just you use different tick boxes to navigate through. So as my learning friend accepts, the landing page, the starting point, was the same for everyone. We say that is actually ripe for generating mistakes. And the key aspect of this application is the letter of the 14th of December, which came in after the application form was submitted, but was provided in accordance with the application procedure.
So you can upload a letter.
Exactly. And other material.
And is on 367, I infer it is from the FTT's judgment, the box I'm applying, that's a drop down, is it?
That's my understanding.
Yeah.
The way the form is generated doesn't seem to reflect how it's produced on the website, but that's what the tribunals below said. So 374. This is the letter. It's called letter of declaration from the sponsor, who is the person who made the application for the appellant. 14th of December 2020. But as I said, provided as permitted by the application procedure.
Sorry, before you go to the letter, can I also just check this? When it says select the category you're applying for, close family member of an EEA or Swiss national, does that cover both Article 2 under the CRD and Article 3?
Doesn't cover Article 3.
So this is only direct family members?
Yes, and to transpose that into the withdrawal agreement, that I think would be Article 10, 1, F, I think.
So this is the 2000 regulation?
No, this is the withdrawal agreement. So, my lords, so this is this would be under the directive. It would be Article 2, family members, not 3, 2.
Yeah.
And in the withdrawal agreement, it would be, I think, 10.1E2. 10.1E2, perhaps, but we can come back to that. It's certainly not an extended family member.
No. Thank you. So if it had been an extended family member, it would have been under select the category extended family member then?
It would be EA family permit. It's a different...
I'm really sorry to interrupt that, but it may help to look at the evidence that the respondent has put in, actually, which shows you what was being selected.
Well, I'm just on that. I mean, you've been granted leave to put it in, but we also have findings. I know that the respondent's been granted leave, but we do have findings of fact. Is anyone going to address what the status is of all this fresh evidence on appeal?
I think the bottom line,
well, perhaps.
Well, let's look at it first.
I was going to say, for these purposes, it shows what the options are.
Yeah, well, that's very helpful.
Yeah, well, for my part, I think that would be helpful. If you don't.
Yeah.
Part of the reason I hesitate to get to my feet is because I seem to have an earlier version of the hearing bundle, so my page numbers may be out of sync. But wherever you find the witness statement of Mr. Peckover, which is the evidence served on behalf of...
Yes.
342 is the end of his statement.
Right. Ends at 312.
So I have it then at paragraph 32 of that statement. Page 336. Mr. Cox.
Okay, 332.
That's
336.
the category application.
That's the drop-down box, is it?
Well, I think it's not for me, but it is.
That's the bullet that you
drop
select.
down anyway. Those were the options. Whether they were drop down or just displayed as a whole.
So the first bullet that you then
It's
click.
not drop-down, is it? That's not the way Gov UK works.
No, it's not drop down.
You
it's
click something and then a
options
new
that
box
you
appears.
select. You pick, and then a blob would appear in the empty
Yes.
circle, and then you go on to the next page, which the statement goes on to explain the next page. Which
Yeah, that's how Gov UK documents work,
Yes.
isn't it? Driving licences, etc.
happily I haven't had to fill it in.
And we can see on 337 the cursor is over. I confirm I'm applying, which so it's not quite a drop down, but the box then picks up.
Yes, and then over the page there's then a thing to click on which explains who is a close family member. So again, the person, if they hadn't already done that and read the guidance, here's another opportunity to see if they qualify as a close family member at this point. And this statement goes on to show that makes clear that it's not somebody like this appellant, essentially. So that's how it flows.
You're on 338 now.
338, yeah.
So on 338, there's an underlined line. What is a close family member?
It's a clickable.
Has that been clicked in order to get these the options?
That would have been clicked in this case.
Yes, that's a clickable link which links back to earlier guidance, which is fundamentally what this statement is about.
But you see the bullet, the dots, the circles underneath that. Have they been produced
Yes.
as a result of clicking what is a close family member?
Yes.
In other words, that's the answer to the question posed in the underlined sentence. Is that right? Nods from behind.
Yes.
So it doesn't say.
I don't. I'm sorry.
It doesn't say, for example, a son is a close family member, but a brother doesn't.
It does.
Isn't.
So
Is it?
if you click on that clickable link, what is a close family member, it links to the guidance, which, for example, the court can see on page 335, just by the top hole punch, what is a close family member? A close family member must be your spouse, child or grandchild.
So
Right. Okay.
this is the material that gave rise to the finding of fact. But anyway,
Yes, exactly.
it would help if by the end of the hearing, not only did we understand the status of the guidance notes and whether we can look at it,
This evidence.
but where, if at all this fresh evidence fits into the scheme of things. Because normally we're bound by findings of fact made by the FTT, so are the UT, because it's only appeals on law, and everyone putting in new evidence is all very interesting, but it's not necessarily regular.
Well, I'll tell you.
You don't need to address it now. We can sort it out as and when.
It's not. Our position is there's no reason why this should come in. We've actually made that position clear in correspondence. This isn't new material in the sense that the Secretary of State was unaware of it or couldn't have produced it below. It was clearly relevant to the issues below, so it can't satisfy the ladder Marshall requirements. And that's why I've not referred to it during the course of my submissions. I appreciate the court may be interested to look at this as wider background to Bene Essay, or you may be ultimately persuaded it should be admitted. But one way or the other, it doesn't, in my submission, undermine the appellant's arguments. But in principle, I can't see how it can satisfy ladder Marshall. That's our submission.
Yep.
Can we look at the evidence that you can see, which is the application form? We've been looking at that, 367.
Thank you.
And the key document, perhaps of the case, is at page 374, the letter I was addressing before, 14th of December 2020. And it's brief and it's not ideally expressed. It was produced by a layperson. But the submission is that on any fair and objective interpretation of this document, it was making the point that the applicant is dependent, is a dependent spouse of this EEA citizen residing in the UK.
Not a spouse.
I misspoke. Sibling, not a spouse, I hope not. Sibling.
Dependent sister.
Yeah. Forgive me. I mean, that's what this letter plainly says. And we say that is sufficient when taken in context, because the context was that that the basis of the application, even looking at the application form, was wholly unsustainable. The person wasn't a close family member. So there is, objectively speaking, clearly a mistake, and objectively speaking, we respectfully say, being fair at least, and erring on the side of doubt, an intention to make 2016 regulations application, or more generally, a 3.2a application.
But if you turn to the application itself, page 371, the relationship between the appellant and the sponsor is said to be brother.
Yeah.
And over the page, there seems to be, I'm guessing these are descriptions of the documents that were put in by the appellant or by her brother, proof of
Dependency.
the appellant's relationship, blah, 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 evidence she is dependent.
Yes.
So it's clear from the application itself, without even looking at the letter, that this was an application made on behalf of someone who was the sister of an EU national and who was said to be dependent on that EU national.
Yes. And that could only be.
Well, that's an application under the 2016 regs.
Exactly. Yeah. So construing this objectively but fairly, that was the intention. And we say that's enough for the purposes of 10.3. That's the simple point. For all the reasons I've developed. So that's how we come within personal scope, if that's important for Article 18. But I just want to be clear, as a fallback, and it's very much a fallback, even if we're not within personal scope, we do say that it may be possible to read Article 18.1.0 in particular as having a freestanding effect, if you're with the appellant that the application that was made was regulated by Article 18, as I've submitted it must be. And we're fortified in that position by what the Upper Tribunal said in the Shellick case at paragraph 62, which is behind tab 19, page 577. This is of the authority.
Where? This is the Shellick in the UT.
Shellick in the UT, paragraph 62. I'm sorry, it's 605 for the relevant passage. You've got the line marking. You may have looked at this before. The expert tribunal in Shellick was of the view that you could give 18.1r a freestanding effect, even if you're not within personal scope.
Sorry, where is this in the paragraph?
62. Yep. 62.
Yeah, because it rejects here. I mean, my lords and my lady will need to read it.
Yeah.
In the Upper Tribunal.
Yeah, I've got it.
So this is 605, my lord. So, and the reason I make that's what it says, is that my learned friend, Ms. Smythe, submitted that Article 18 just didn't apply because if you fell outside of personal scope, which the Upper Tribunal said was the case in Shellick, you didn't fall within personal scope because there was no 10.3 application. Obviously, our primary and firm submission is we did make a 10.3 application, but if we didn't, we can rely on this passage as indicating that Article 18.1 can be given freestanding effect. I appreciate that there are issues with that submission, but in the context of Article 18.1.0, which talks about correcting defects to an application, that context and purpose of 18.1.0 may support that approach. But it's very much a fallback submission. So can I turn now to the interpretation of Article 18?
You said there were problems with the submission. What do you say those are?
Well, the problem, I don't want to do my learned friend.
No, I appreciate that.
But the problem is, if you interpret Part 2 overall, it seems to work in two stages. You get you get in through 10, and then that's the first stage, and then you get into the Title 2 residence rights provisions in which Article 18 appears. And if that, and indeed, Article 10 is framed in terms of personal scope for the Part 2 provision. So one way of looking at this regime is to say if you're not within personal scope, you're not within Part 2. But that submission was explicitly rejected by the expert tribunal in Chelik at 62, which is why I've taken the court to it.
And what do you say the answer to that objection is? Obviously, you rely on the Upper Tribunal in Chelik. What else?
The answer...
They don't give any reasons, they just assert.
I appreciate that. The answer is that Article 18 governs procedure. It's the only aspect of Part 2, really, that specifically deals with a particular process. And we say that, albeit wrongly, albeit mistakenly, the applicant used the Article 18 procedure that the UK has adopted here. And I ask rhetorically, what other procedure could it have been, bearing in mind that, as we point out in the supplementary skeleton argument, the Secretary of State just has one procedure for out-of-country applications governed by all of this, and they can't all be explained, we respectfully submit, by Article 14.3. My learned friend accepts that, I think, because her submission is 14.3 doesn't cover 10.4. But my learned friend can explain that in due course. So we say we did apply under a procedure regulated by Article 18, even if the applicant was not in personal scope, because that was the procedure that she used, that the appellant, used, or was used on her behalf. And if that's right, then it's not too difficult to say, well, you have procedural rights in respect of that procedure. One of them is the Article 18.10 procedural right, and that gives you certain advantages. For example, it allows you to realise your mistake, to correct your mistake, and then bring yourself within personal scope. And I appreciate there's a degree of bootstrapping there, pulling oneself up by one's own bootstraps, but that's not an issue when one bears in mind the purpose and context of 18.10, which I'll come to in a moment. So turning then to the interpretation of Article 18.10, if we just look at the language of 18.10, so it's on page 16 behind tab 1. I'll invite my lady in my laws just to read it. Now, the First-tier Tribunal said that this did not apply because, on its correct interpretation, it didn't extend to allowing defects that were so fundamental as to mean you've made the wrong application entirely, you've made an application under entirely the wrong category, to be corrected. The Upper Tribunal didn't really grapple with this, but we submit that that interpretation of 18.10 is wrong. There's simply no reason, applying Vienna Convention principles, to interpret Article 18.10 narrowly in that way. It should, if anything, be interpreted broadly. And so the more fundamental the error, the more reason you need Article 18.10 protections. And we also submit that giving Article 18.10 a broad interpretation would effectively ensure, or at least help to ensure, that states comply with all of the minimum procedural protections that I've explained earlier. It would also meet my learned friend Ms. Smythe's objection that an obligation to effectively decide an application that's made in the wrong way would be unworkable or problematic, because the application wouldn't have included all of the required information for the extensive examination. If you're given the chance to provide that material by perfecting or correcting the application, then that objection is addressed.
And presumably you say in this case, that material was provided because of the references in the application form to material proving dependency.
Yes, there was evidence.
Relationship.
Yeah. There were evidence and assertions.
So all the material that was necessary for the application to be considered was provided with it.
There was certainly, yes, it could have been considered, and obviously the substantive consideration was for the Secretary of State, but material that met the requirements was provided.
So the only bit of 18...
Well, it was for the Secretary of State to decide whether or not the material showed dependency and the rest of it, but presumably your submission is that material was provided with the application.
Yes.
So the bit of 1810 that you actually rely on is not help to prove eligibility, it's to avoid any errors, i.e. ticking the wrong box.
Yeah, that's right.
And to correct any deficiencies.
Exactly. Thank you. I mean, it really is. It couldn't be broader. And I'll come back to the...
just going back to the point about whether this only arises if we're within personal scope. Looking at how do you address that? How does this play into play with 10.5?
Well, what it would do is it would allow then the state in question, the UK here obviously, to conduct the extensive examination. But I would also submit that you should read Article 1810 broadly in the light of the 10.5 obligation and the other procedural points, obligations that I have identified. So, and just to be clear, we say we're within personal scope for the reasons I've given, but if we're not, actually there's nothing wrong in saying, well, this applicant applied under a procedure regulated by Article 18, that does appear to be the position and is our submission, and so why can't you have the benefit of 1810?
And that's your first ground of appeal?
That's our first ground of appeal.
Can I ask you what you say, because it's a point raised by the Secretary of State, what you say the consequence would be if you were right and that they should have said, by the way, you've ticked the wrong box?
Yes. Well, in this case, that would undoubtedly mean that there was a breach of the Article 1810 right, which would mean that the appeal under the relevant regulations had to be allowed. And it would then fall to the Secretary of State to implement that appeal. And I appreciate that the Secretary of State raises technical obstacles bearing in mind the current circumstances. But our short submission in response to that is very broad discretion under the 71 Act, Immigration Act 1971, and there is a legal obligation to give effect to a decision of the tribunal as best as that can be done. And there is also a legal obligation to put someone who has been the subject of unlawfulness established by tribunal proceedings, as far as is possible, into the position they would have been in, had it not been for that unlawfulness. That's the RSAN,
which would be
20 point.
Remitting it to the Secretary of State to examine the personal circumstances.
Exactly. Under her general discretion, bearing in mind the very unusual circumstances here with the very complicated transitional arrangements and all the rest of it. And for the purposes of the suggestion that this appeal is academic, I simply need to point out that we would succeed under our appeal and the Secretary of State could do something in the light of those points, and we say should do something. It may be if the Secretary of State chooses not to do something, there may need to be further proceedings. I don't know, but that's not something that indicates in any way that this appeal is academic. So can I just, before I finish this point, refer again to the guidance note, again with all the caveats that we discussed earlier about how this can be considered. Page 3 of that, sorry, not page 3, page 4, paragraph 2611, line marked on the left. Let's invite the court to read that. And my submission, that's very strongly supportive of our approach to Article 1810, and including in respect to the fallback approach if we're not within personal scope. And I note the last sentence or clause of the last sentence of the first paragraph. What this is pointing out is that...
It's your cliff edge point.
Exactly.
But do you need this for your cliff edge point? Because isn't the cliff edge point part of the context in which the agreement should be construed?
Indeed. And that's why I can put our primary case in terms of 10.3. But if for some reason you're not with me on 10.3, being within personal scope, we do say that actually the cliff edge point can be addressed by giving 1810 a fairly broad meaning. Then that would allow you to bring yourself within 10.3, and we submit there's nothing wrong with that, because, I mean, certainly the Commission thought that that was the sort of thing that 1810 was there to deal with. So those are our submissions in respect of Ground 1.
Thank you.
Ground 1A I can deal with very briefly. It's essentially another way of making the points I've been made. Oh, I should just say, just to be clear, on 1810, what the Upper Tribunal said as to why 1810 didn't apply was essentially to adopt the reasoning in Batul in respect of 181R. And we've submitted in the skeleton argument, the appeal skeleton argument, amended appeal skeleton argument, that just can't be right, because the 181R obligation and the 181O obligation must be different. And the O obligation is very, very clear. It doesn't allow for balancing of administrative convenience or in respect of an overall evaluation of proportionality. It says what it says. So, Ground 1A, and there are two aspects to this actually. There's 181R, and there's also a direct reliance on regulation, on Article 21 of the withdrawal agreement. And we say...
I'm sorry, and Article 21?
21, the safeguards that we've looked at, and that brings in proportionality. So that's the that's an aspect of amended Ground 1A. So if for some reason we can't rely on Article 18, we've got Article 21. And the short point is, bearing in mind the cliff edge, effect of domestic legislation, and all of the points I've made about procedural rights, proportionality required the Secretary of State to do something other than simply say, you've made the wrong application, we're not going to consider we're not going to give it the extensive examination it should be given. Now, they could have made a decision which would have triggered a right of appeal on the basis that it was treated as an application made under the 2016 regulations and considered on that basis. Or they could have, the Secretary of State could have asked for further information or done something else. Simply saying we're not going to look at it at all is not compatible with the facilitation obligation and the procedural rights I've mentioned. The extensive examination requirement, if you like. So that's Ground 1A. And finally, or penultimately, because I need to deal with the residual issues about whether the appeal is academic.
Yep.
Ground 2. Now this makes in a sense, quite a new point or different point to the points I've been making earlier. But the point has force because of the banger procedural obligations or procedural entitlements to an effective judicial redress procedure that arise in respect of an application that is made under 3.2a of the directive and 10.3.
Do you mind just setting out what you say your ground 2 is? Because in your amended grounds of appeal, you have to chase it through a whole series of different documents. The Upper Tribunal was wrong to dismiss the first ground of appeal before it should have accepted the FTT. Just tell me what you say is the second ground of appeal, because then I can make sure that I've got it accurately.
Yes. It's the sentence 6 lines up from the bottom. Also appealed under the
6 line up from the bottom of 15 or 16
of ground 2 itself. So if you're looking at my amended skeleton argument, page 2.
No, I'm looking at your amended grounds of appeal on page 2.
Do you mean the sentence that begins the first-tier tribunal had assumed? Is that what you mean?
That's it.
He means the third sentence line from the top.
Had assumed.
So it's the error of the FTT which the UT didn't correct.
No,
That's the point?
and it's the sentence beginning, however, the appellant has also appealed under the 2016.
It's an omission by the FTT which was not corrected by the UT.
Yes. So just to, I thought I could refer to the way the grounds expressed, but obviously my Lord Justice Dingemans is quite right. It's not expressed ideally. The simple point is, we had a right of appeal under the 2016 regulations because there was an EEA decision, and the First-tier Tribunal and the Upper Tribunal erred in law by failing to appreciate that.
So I think my Lord wants you to...
That's fine. Yeah,
tracking it through, it says the appellant had also appealed. So there is,
Yes.
in the papers, an appeal which was not dealt with. Is that your point?
That's essentially the point, yes. And because...
So where do we see that in particular?
Well, there was one notice of appeal, but it constantly referred to, and did refer to, the 2016 regulations.
Could you just show us that?
Yes. Give me a moment.
Because my understanding is the FTT and Upper Tribunal said, well, you didn't have a right of appeal because you didn't make an application under the 216 regulations.
Yes,
is
they
that
said,
right?
effectively, they...
And what do you say the short answer to that is?
Well, the short answer is what does EEA decision mean? That's the short question, and the short answer is it covers the January 21 decision in this case, because that decision was a decision that concerned rights under the 2016 regulations, and that's sufficient. So I need to take the...
224, 225. That's the appeal notice, isn't it?
Yes. Thank you. So I think it's probably 232.
Yep.
And there's reference to EU, Appendix EU family permit. And there's reference to extended family member regulation, 8 of the 2016 regulations.
Well, it begins, 232, the box begins by saying the decision is in accordance with the 2016 relations.
Exactly. Now, so the way the appeal was presented, and I wasn't involved at that stage, but the way it was presented seems to have been on the assumption that this was an appeal under the 2016 regulations.
And where do you say we see from the FTT's determination that they just overlooked that or dealt with it impermissibly?
Well, this is the point. This is why we say the FTT erred by failing to appreciate the nature and scope of its jurisdiction. It just didn't look at the legal framework under which its jurisdiction arose. It looked at this. It looked at the substantive issues that were put before it, but it didn't consider whether actually it had jurisdiction by virtue of the 2016 regulations or the Citizens' Rights Appeal regulations.
Is this a flip side of you saying that you're within scope of Article 10 anyway?
I think so.
Yeah, I can't see it really adds very much more to that.
Does
But
it-
I may be wrong.
Perhaps not.
Does it feel as though it adds much? Ground one feels like your main peg.
Maybe. Perhaps if I can briefly develop ground two, perhaps
Sorry.
you'll see another peg.
So the point is the point you're making that in substance the FTT was dealing with an appeal under the 2016 regulations.
Yes.
And it failed to appreciate that that's what it was doing.
That's the point. Always has been the point, my
Yeah.
lady. And I mean, insofar as my lord is suggesting there may be some procedural issue, was the right type of appeal instantiated? That's never been looked at, but we don't think that's a problem.
Okay.
And my learned friend doesn't say it's a problem. So the real question in my submission is, was there a right of appeal under the 2016 regulations?
And you say there was because there was an EEA decision.
Exactly.
In substance.
Exactly.
Yeah.
And we'll very shortly come to the relevant provisions that need to be interpreted there. But we say those provisions should be interpreted broadly, applying the Marl leasing principle, in order to deal with all the procedural rights that I've highlighted, and in particular the bank entitlement.
Right.
So that's why perhaps there is an additional peg.
Okay.
Ground two.
You've indicated where the peg is. Now show us it.
I'm grateful. Let's turn then to the key provisions within the regulations for this point. So it's Regulation 36 that confers the right of appeal.
Just so I know, you're going to share something which isn't mentioned in the FTT decision at all. Is that right?
Yeah, and that's our point, my lord. Our ground of appeal It was always
there.
FTTF because it just didn't think about its jurisdiction.
Okay.
But obviously, to make that point work, I have to show that there was a right of appeal. Otherwise, it's without any substance.
And it may be you have to show that it was argued. Not you asserted to it. We've seen where it is. Sentence 1 in the grounds.
Well, it wasn't argued specifically in the FDT, but there was no engagement with whether it was a 2016 regs appeal or a CRA appeal. But it was a ground of appeal in the Upper Tribunal, which we were given permission to argue.
Okay.
So it was fully fleshed out in the Upper
All right. Well, let's go back. You want to track through.
So just on the point that there is a right of appeal, which I think is the key issue in terms of ground 2, Regulation 36 confers the right of appeal. It's at tab 6. So it's a 2016 regulations, page 132.
Regulation 36 or 32? I think you said 32 before.
I'm so sorry, I keep misspeaking.
No, don't worry.
36.
So 36 of the 2016 regulations.
That's it.
Yeah, thank you.
Page 132.
Yeah. Bottom of 132.
Yep.
Going over. And it's actually just that first paragraph of Regulation 36. Subject of an EEA decision may appeal. That's it. So we then go back to what an EEA decision is, and that's determined by Regulation 2, which sets out a fairly long list of definitions. The relevant definition is on page 115. EEA decision means, and I'd invite the court just to remind itself of that definition up until the end of B. It's quoted in my skeleton.
Right.
And you contend you had a decision under these regulations?
Well, it's the words under these regulations that cause me difficulty.
Well, that's why I was asking you,
Yes.
you for your submissions. Because, otherwise, we read it, think, oh, that might be difficult, and I've not got your submission about what the answer is.
Right. The answer is you should read this definition compatibly with the Banger procedural requirements and the broader procedural requirements. And so that language under these regulations, applying the Mar-Leasing principle, is not an obstacle.
Okay.
So under these regulations means more than that.
In this context, what it means is a decision in substance that, and then the rest of the definition. But we can look at how the Mar-Leasing principle operates in the Swift case, which was actually applied in a case called that was actually applied in a case called Riemann at tab 26. I don't ask you to turn to it now, but it was applied to the 2016 regulations in that case in respect of interpreting 21 in a way that was compatible with EU law. So the court may want to look at that. I'm not going to take the court to it, but it's there.
Raymond at tab 26. Okay.
But the point I am making is in terms of the interpretation of EEA decision in Reg 2 just depends on the application of the Mar-Leasing principle in the light of the points I've made about the requirements of EU law and the withdrawal agreement. And the requirements and the Mar-Leasing principle is helpfully set out and summarised in terms of its effect in the Robertson and Swift case,
Yes.
which is behind tab 36. And it's paragraphs 20 to 22. Paragraphs 20 to 22, beginning on 10:13.
Well, do you want us to read the Vodafone passage from Chancellor?
If it would assist, yes. I mean, these are familiar
Okay.
principles.
Do you want us to go through it now, or?
No, I think you can do so in due course.
Okay.
I'll just make the headline that I say you take from this. Effectively, you've got a very, very powerful principle of interpretation that lets you effectively rewrite legislation if that's required in order to give effect to directly effective EU law. And so the words under these regulations in Regulation 2 are no problem, with great respect, applying the leasing principle as explained in SWIFT. If I'm right about the requirements in terms of facilitation, extensive examination, and the banger procedural judicial redress requirements that we've looked at. For what it's worth, we also try in the skeleton argument to give you a conventional textual way of reaching the conclusion we want you to reach about the interpretation of EEA decision, but I appreciate under these regulations is difficult. But it's not difficult when you apply leasing. And what's striking in my submission is that my learned friend doesn't address any of this in written submissions. And ground 2 is effectively, I mean, there are a few paragraphs devoted to it.
Well, as I understand it, the Secretary of State's position is that you didn't make a 2016 regulations application, and that's that.
Right, and as we've set out in the skeleton, it's 60, 60, 74 of my skeleton argument that deals with ground 2, 60, 60, 74. But what we say is, it doesn't matter, what matters for the purposes of the right of appeal in 36 is simply whether you've made an EEA decision. And you can, in principle, therefore, have an EEA decision even if Regulation 21 is not complied with. And one of the points we make in that respect is to highlight the distinction between limb A of the definition and limb B. So let's just go back to Reg 2 of the EEA regulations.
And which parts of the directive, by which I imagine you mean the Citizens' Rights Directive, do you rely on for the leasing interpretive provisions?
Well, I think it's the obligation to give effect to the minimum requirements for facilitation, the extensive examination. That's point 1. That's Roman. And point 2 is banger, the entitlement to have a judicial redress procedure that allows for a proper factual examination. Now that really does, that can only be addressed by giving a right of appeal of the kind that the 2016 regulations affords. And so in my statement, that does add something here.
But I mean, just so that you can deal with it, I mean, this is a bit circular back to argument grounds 1 and 2, because if you're right on that, you would have succeeded, and if you're wrong, that facilitation doesn't mean reading an application in the way that you want, then you're not going to succeed anyway.
Yes. If we don't succeed on 10.3,
yeah,
we don't succeed on ground 2.
No.
The reason it might add something here is because of the points the respondent makes about the scope of Article 18 not applying at all. And it also, I would respectfully suggest, does provide a sort of practical and legally workable way of addressing the procedural rights that we rely upon. To say, well, you have a right of appeal, so that can help you.
Now, the UT dealt with, you weren't before the FTT, and then you ran this argument before the Upper Tribunal, and they dealt with it, I think, at paragraphs 46 of their decision.
Yes.
Are you going to say anything about why what they say there is wrong? 46 onwards. I think it's 49, isn't it? They say that. Tell me if I'm barking up the wrong tree, Mr. Biggs, but it looks as though they're saying that it wasn't an EEA decision. Am I in the right place or not?
My computer's being annoyingly slow. Just bear with me, my lord, if you would. Yes. I think you're referring me to 49.
49, well, 46 to 49.
I'm grateful.
I think, am I right? That is where they deal with your points, or am I barking up the wrong tree?
That is right. Essentially, the reasoning is that it's not a regulation that falls within an application that fell within Regulation 2.
It wasn't an EEA decision so as to bring the case within Regulation 2.
Because it's a mislabelled application.
Yes, because it didn't satisfy 21. Now, with great respect to the Upper Tribunal, that misses the point of Ground 2, which is to say, or one element of Ground 2 is dependent on this proposition, which is it doesn't matter whether you satisfy 21 if you meet the definition of an EEA decision. But this is a pure point of law, my lords, and it's either right or not. So with great respect to the Upper Tribunal, its precise analysis perhaps doesn't matter very much in the end. You're either with me on the analysis I put forward or you're not. Those are the submissions in respect of grounds, well, all of the grounds of appeal.
Then you want to sweep up with some final points, including academic.
That's all I think I want to sweep. Oh, actually, there's one thing I should say. I've been told that actually it was argued in the First-tier Tribunal that the 2016 regulations were there. I've been referred to paragraphs 7 and 13, which I'd invite the court to look at.
Of the decision?
Of the FTT's decision. Paragraphs 7
well, in fairness to those who sit behind you, if I misspoke, I want to we have a chance to correct it. So 7 and 15, you say?
Yes, I think 217.
Thank you. Yeah, well, there's 7. And 15?
I think it's 13. And
13.
218. Now, I perhaps wasn't clear. I had intended to make the point that, and I think I did make the point, that the substantive requirements of the regulations were argued in the FTT.
Yeah.
What was not addressed by anyone at that stage was the FTT's jurisdiction.
Okay, thank you.
Is the appeal academic? You've got most of my submissions on that already. You've got the supplementary skeleton argument. In response to my Lord Justice Dingemans' point, during the course of argument, I explained what could happen if we're right about 1810. The same would happen if we're right about ground 2. So one way or the other, the appeals below would be allowed. The appeals, statutory appeals, would be allowed. That would then require the Secretary of State to go away and implement the decisions, which would in turn, because those decisions would be binding on him, and that would then require the Secretary of State to, as far as possible, put the appellant in the position she would have been in had it not been for the unlawfulness that grounds 1 to 2 seek to establish.
And
that's the ARSAN obligation.
Sorry, I thought you finished. And what were extended family members getting in the run-up to Brexit if they did manage to fill in the right form and prove the relevant provisions?
Yes, so this is the point that my learned friend Ms. Smythe rightly makes in respect of my para 66 of the skeleton argument. The tribunal wouldn't do everything. It would have to look at the factual basis, so it would look at dependency, but ultimately the case goes back to the Secretary of State for the extensive examination. So it's a matter of discretion, informed by EU law controls.
And what was, assuming the Secretary of State was satisfied for A and other, what was the Secretary of State granting by way of leave?
Well, so it would have been a family permit. That was the application. And my learned friend is right to say, well, the appellant is now in the UK. But if we're right about the points we've made, then the way the Secretary of State has acted here in the legal scheme is not compatible with her rights. And that's why the appeal would be allowed. And so she's effectively been deprived of the opportunity to take advantage of the withdrawal agreement.
How could she be put in a better position now than she is at the moment?
She should be potentially. I mean, obviously, this is a matter in due course for the Secretary of State.
How could her position be improved?
The Secretary of State could treat her as though, for example, she has a residence card or is entitled to be considered for a residence card, which would then give 5 years without conditions, such as limited
Okay. So
Right.
a 5 year.
5 years and conditions allowing for benefits, right to work, etc., that you would get under the withdrawal agreement, you don't get as a skilled worker. So that's a
Okay.
tangible benefit. And we are entitled to submit, by reference to our Senate paragraph 120, that the Secretary of State has that obligation to at least think about how to undo the fact that she's acted unlawfully, which she would have done if we were right about any of our grounds.
But the short point is, you say you should have 5 and not 3 years, and different entitlement to benefits.
Yes, and that's a point about substance. My learned friend, Ms. Meyer's argument is about form, and she rightly points out that there are some technical problems that arise just because of how things have developed. But in my submission, the Secretary of State has ample power under the 71 Act to use her discretion sensibly and to give effect, in substance, to this court's decision.
Do you want to just point to something to support that submission?
Certainly.
What can the Secretary of State actually do, given that the power to do what she would have done is gone?
So this is the supplementary skeleton.
Oh, yes.
And I've set out references to all the key cases there, and the propositions we make by reference to them. But just to deal with the point briefly orally, if I may, if we go to the supplementary bundle,
What your authorities bundle?
yes, forgive me, supplementary authorities.
Yeah.
If we turn to the Munir case, which is tab 3, starts at 69 for those using an electronic version. It's paragraph 44 and 46. 44 is on 83. And it's simply making the point at 43, Lord Dyson simply making the point at 44, forgive me, that the Secretary of State has an enormously broad discretion under the 71 Act to grant leave to remain outside the immigration rules on the basis of policies or on a freestanding basis. And so at 46, in the conclusion, bottom of 83 going over leave, the Supreme Court concludes that the Secretary of State can waive the immigration rules in his discretion and can effectively grant leave where that's considered appropriate. And we submit that it would be appropriate in this case in order to put the appellant in the position she at least may have been had the illegalities that we say underlie grounds 1 to 2 not arisen. And that obligation is a cast iron obligation that's recognised in the cases. It's the obligation mentioned by Lord Justice Underhill in the Arsan case, which is at tab 2 of the supplemental authorities.
Yeah.
Paragraph 120 is on page 57. We've line marked the whole series of passages to give the context for 120. And I'll just explain that context in a moment, but the point that is being made at paragraph 120 is that if the First-tier Tribunal, in that case in a human rights appeal, but nothing turns on the nature of the appeal, establishes that there was an historical illegality, then the Secretary of State will be obliged, in the exercise of his discretion going forward, to take steps to address that illegality, to put the person in the position, as far as that's possible to do, that they would have been in had it not been for that illegality. So there is real substantive punch in the authorities to the point we make about the Secretary of State having this broad discretion and being able to use it. And I'll just make good the promise to deal with the context here. This was a case involving the suggestion that you could have a human rights appeal in order to deal with an historical removal decision that made a person an overstayer. Lord Justice Underhill at paragraph 120 says, yes, you can do that, because if the appeal is successful on the basis that the historical decision was unlawful, then this obligation will arise. So that gives you effective protection, an effective remedy in respect of that sort of issue. My lady, my lords, I think those are my submissions.
Well, well
1
done,
minute
Mr. Reed.
left.
Spot on. Thank
Thank you.
you very much. Well, we look forward to hearing from the interveners after lunch. Thank you very much. 2 o'clock.